defective notice to appear and dismissal, defective notice to appear and cancellation of removal. Can you claim that your notice is defective so that you can dismiss your case, or you can ask for another type of relief such as cancellation of removal? In this video, I am going to answer this question because this question was asked to me during a consultation. Well, this is a case where someone claimed that their notice to appear was defective. In order to claim that, you have to look at the notice to appear. If the first notice to appear lacks time, place, and date of the hearing, then the notice is defective. And this is the argument you're going to have to make before the immigration judge in immigration court. However, just know that DHS can be afforded the opportunity to correct the mistake. So in other words, the argument can stand or the argument can fail. But let's say that you make this argument and you are successful in making the argument of defective notice to appear, and you want to claim cancellation of removal. One of my clients, we previously talked about it, but we couldn't do it because the basis for taking this claim was that we are going to claim cancellation of removal. But when we assess the case, we find out that the cancellation of removal case is very weak. Why? Because even though the 10 years requirement has been met, or the other requirement, good moral and character, have been met, however, the requirement of extreme and unusual hardship hasn't been met yet. And it's going to be really difficult to actually prove this case in court. I strongly suggest that according to me, my personal opinion was that this is a weak case, and I wouldn't put you in that position, especially that your case has been administratively closed. So I don't want to put you back in removal so that we can just lose it and you're going to end up with an order of removal, and that's going to be more stressful to you. So what's going to happen? What's going to happen is this. If you're claiming defective notice to appear, it means that you're claiming that the notice lacks the time, the place, and the date of the hearing. And let's say the argument is successful and you want to claim cancellation of removal. Then in order to claim cancellation of removal, there are 4 requirements. The main requirements: 10 years of continuous presence prior to receiving the notice to appear. And because the notice was defective, then it's going to waive that. If you didn't meet those 10 years, then you're going to calculate the day that they corrected notice to appear, right? To make this 10 years. You have to be a person of good moral and character. No criminal offenses that cannot be waived, like terrorism, espionage, those type of felony, it cannot be waived. Then extreme and unusual hardship to your qualifying relative. That will be a spouse, a child, parent, lawful permanent resident, or U.S. citizen. Extreme and unusual, it's very higher standard because it has to be really something extreme, something unusual. It doesn't happen to anybody. It just doesn't happen to everybody. It's not common. It's rare. Let's say somebody has some type of rare diseases. That's extreme and unusual because not everybody has those type of diseases. If you're only claiming hardship in terms of finances, it's pretty weak because if we look at the statistics, a lot of people live in poverty. The argument, it's really a little bit weak if it's just because of financial hardship. If you're just claiming, let's say, divorce, a little bit weak if it's not combined with other circumstances, because they're going to look at the totality of circumstances as well, right? So if you have some weak argument, let's try to make a lot of them, and the totality of it can raise to the standard of extreme and unusual hardship. So that's how you claim cancellation of removal. Remember that there are only 4,000 visas available for that. That's why the standard is very high. I remember we argued one case in November of 2022. Until today, we haven't gotten a decision from the judge because the decision is still on reserve. They keep saying that we're waiting for the visa to become available. In other words, they're just trying to see whose case is better than us so that they can see if they can grant it to us or grant it to the other person, because you are competing with 4,000 people. So that's why my opinion was that I'm not going to put this person in removal proceedings just to risk this order of deportation, because the case is very weak. But anyway, that's how you claim defective notice to appear, and you claim cancellation of removal as a defense. If you need to assess your case, you need a consultation with me, my friend. You can schedule it by using the consultation link in the description box below. Until next time, bye-bye.